Hello and welcome to this, our first online Wills Week. My name is Kathy Hawksworth. I am Counsel and Philanthropy Advisor at Edmonton Community Foundation. Thanks to an amazing group of volunteer lawyers, this year Wills Week brings you 10 presentations, each unique and designed to inspire and guide you in the proper preparation of your estate plans. These plans include not only a will to protect your family, your business, and your assets, but also 2 additional documents to help you during your lifetime when you're temporarily or permanently unable to be as independent as you would like to be. Understanding the hardships and additional costs that occur when these estate documents are not in place correctly will help you appreciate the value of getting professional advice for you and your loved ones. This week, you'll hear from lawyers about things done well and things gone wrong, how to plan for particular situations like blended families, a family member with disability, and how tax planning can increase the amounts you can give. On Thursday evening, you can learn about how gifts you include in your will to support your favorite organizations and causes can help save taxes and allow you to create a meaningful legacy. Edmonton Community Foundation is pleased to provide this Wills Week resource for Alberta-based wills and estate information. It dovetails nicely with our usual role as a trusted resource for how organizations large and small enhance our lives here in Edmonton and further afield, and how to create gifts that reveal your values in a way that fits for you. For this session, we're very fortunate to welcome Jacklynn Pivovar, a partner with Miller Thomson. Jacklynn has been practicing law for over 16 years. She practices exclusively in the area of wills and estates. She has extensive experience in estate litigation matters, including complex disputes related to wills, trusts, and capacity, as well as other disputed estate matters. She also has experience in estate planning, right from the beginning, right through to management of the estate. In her spare time, she provides support to our community in a number of ways. The most fun is she's a judo instructor and has her 3rd degree black belt in judo. So I'm pleased to turn this over to Jacklynn. Jacklynn, take it away.
Thank you so much, Kathy. So as Kathy mentioned, I'm kind of the first of the webinars to start today. My topic today is fighting the terms of a will, how claims arise and how to avoid them. So a little bit about me. So in terms of going forward, kind of looking at this joke as ocean view, or would you prefer to watch them fight over a will? That's kind of the key question I look as in estate litigation, and why it's important to have proper legal advice when you're doing your estate plan. There's many ways how estate claims arise, and we're going to go through each of these in detail today. It includes challenges for will formalities, will interpretation, capacity and undue influence, family maintenance and support claims, joint tenancy, and of course, common problems we deal with in dealing with charities that we see on the litigation side. So the first issue that I want to discuss with you guys today is will formalities. So for a will to be valid, it needs kind of 4 concepts. It has to be executed. The person has to have knowledge and accept the terms of the will. They have to have capacity, and they cannot be unduly influenced with respect to preparing or signing the will. So looking at this, they were sad when they found out their wealthy grandfather had died in an earthquake, but they were devastated when they discovered he had written his will on an Etch-a-Sketch. So the key question is, in Alberta, what makes a valid will? Is the Etch-a-Sketch truly something that would be valid here? So in Alberta, there's actually 2 types of wills. A formal will, which is a will that is signed by the testating. It's written. It has to be signed by 2 witnesses, both present at the same time, and the witnesses must sign the will in the presence of the testator. The other type of valid will in Alberta is something called a holograph will. So holograph will is entirely in your own handwriting and signed by you, and no witnesses are required. So with these types of wills, I often see issues that arise. So question that people always ask me, well, what about a will kit? Is that valid will? So question whether that's better or worse than nothing. From my point of view as an estate litigator, I always treat will kits as a make work project for me. That's how I make my money, because there's so many mistakes that get made with a will kit. And I often see a lot of mistakes as well with the use of holograph wills. Some people do formal wills where, for example, they type it themselves, and so part of it is typed and then they sign it, but they're missing the witness requirements to be an actual valid formal will. Recently had a situation where a mother had 3 children, where unfortunately 2 of her sons had predeceased her and she only had her daughter left. In her will, she wanted to leave all of her estate to her daughter. So she had typed it out herself and then signed it. Then she had her daughter's spouse witness the document. So unfortunately, it was invalid for 2 reasons. Number one, of course, it only had 1 witness rather than 2 witnesses. And then unfortunately, it voided the gift to the daughter because her spouse acted as a witness. And this often happens when people have will kits or doing them at home by themselves, because they don't understand the witness requirements with respect to making a valid will. And that's when it comes to litigation, because we want to try to give effect to the testator's intention, which of course we want to validate a proper will. With holograph wills, I often see problems as well when people put it in their own handwriting, because again, they don't understand the law or don't understand the significance of what they're doing. I recently am dealing with a matter where the mother had, again, 4 children, one, of course, a son, the 3 of them daughters. And she did a holograph will, meaning it was a valid will overall because it was wholly in her own handwriting and she had signed it herself. But it had a lot of problems in it. It said basically, I leave my farm to my son consisting of the following legal descriptions. And then she just listed the legal descriptions. And then it said, and to my daughters, I leave blank. And it literally left a blank there, but then she had signed it. But the question was, well, is it a valid will? Well, what does it mean? When she said farm property and then legal descriptions, unfortunately, the legal descriptions that she had put in the will were not her proper legal descriptions of the land. And then with respect to the word farm, well, what did that include? Did that include the equipment, the cattle? Like, where does that go? And there was no residue clause. So what happened with the residue of the estate? So there was also a partial intestacy in this matter. So we're still kind of dealing with this matter kind of going forward. And the question is, well, did she truly intend to sign it as her last will? Was it just a draft? Was there concerns of undue influence? Because why did she not have the proper legal descriptions in the document? And these are all questions that I have to deal with as an estate litigator. The court does have the power to rectify a will, to make sure to try to give effect to the testator's testamentary intentions. However, of course, the cost and the delay in having to rectify an invalid will is much more different than, of course, if you were just to draft a valid will and have proper legal advice from the beginning. And that's kind of the intention we have here with respect to Wills Week, is trying to educate and provide information to ensure that we have proper estate plans put in place. On average, for me to do a simple estate plan, which includes your will, power of attorney, and personal directive, the costs range between $1,000 to $2,000, depending if you're an individual or a couple. But unfortunately, the cost to try to rectify a will after the fact is significantly higher than that. I've had matters cost up to, like, on average, about $10,000 if they're uncontested, just to try to validate an invalid will. But I've had them cost over $200,000 or up to $500,000 in trying to interpret a will and have it rectified when it's contested on the other side. So again, kind of explains the importance of making sure that you have a proper plan put in place, because not only do you have the costs involved, but there's significant delay because you can't proceed with administering the estate because we don't have a valid will. Kind of other issues that I see is the will interpretation. Basically, what happens if the will doesn't make sense? I see this quite often, and I'll use that farm example as a good example. Well, what did the testator mean by the farm? Did the farm mean the actual legal land descriptions? Or did the farm mean everything, including the equipment, the cattle, the granaries, everything like that? So you have to make sure when you're drafting the estate documents that you're not ambiguous in terms of what the terms mean. And unfortunately, when I see things like will kits being used or holograph wills or your own wills that you type, these kind of nuances aren't often dealt with, and it becomes an interpretation issue after the fact. If the court can't decide in terms of the interpretation of the will, the gift might fail, and that's obviously not the intention of the testator, but we can't proceed if we don't know what the will says. In terms of the next issue, in terms of making sure it's a valid will, we have to make sure the person has capacity. So capacity can be varying from day to day. So capacity is required at 2 times: at the time of giving the instructions to prepare the will and at the time of the execution of the will. You can, of course, have varying degrees of capacity. Somebody could have a really good day and the next day not so well. A good example, I know in my own family, I had a situation where my father was in the hospital, and one day he was perfectly great, and the next day he wasn't as good anymore because, of course, the drugs and medication that he was on. So you can have somebody who has capacity one day, but not necessarily the next. So we really have to look at the capacity at the time, number one, when they give the instructions to the lawyer, and then number two, at the time of execution of the will. So what is the test for capacity? So the test for capacity, as lawyers, we kind of watch for this when we're meeting with clients to make sure that the person has capacity to make a will. The first, of course, they have to understand the nature and extent of their property. And number two, who their heirs are, i.e. who are their family members or other people you'd expect that they may want to leave their estate to. And then what provisions are being made in the will? For example, are they writing someone out of the will, or are they leaving it to people that we would intend that they would keep it out, or considered people who they should leave their estate to, which we're going to talk about a little bit later under family maintenance and support claims. An individual also has to appreciate the duty to the heirs and whether they meet those duties, which again is under those family maintenance and support claims, and whether the will maker desire to dispose of their property. So again, who are they giving their property to, and do they have obligations to them? So again, you can have capacity to write a will, and you can write out certain people under your will if you want to. As lawyers, we make sure that we watch for these things to make sure the person has capacities. And we actually act as witnesses if someone was just challenged a will. So as a lawyer, when I'm drafting a will for a client, I make sure to kind of look at this test and keep accurate notes and records to make sure that I can validate and swear an affidavit that says that my client had capacity at the time of signing the will. When you're doing individual wills on your own or without a lawyer, or will kits or a holograph will, you don't have that independent witnesses who can act on your behalf if the will is challenged. So if I'm concerned about someone's capacity, say for example, a client comes to me and says, I have 3 children, but my one child, I haven't been involved with my child for, over 30 years, I'm estranged from them and I don't want to include them in the estate plan. That's you can decide to do that as long as they're not a family member under the family maintenance and support claim. But I always like to make sure that my clients don't have the ability to have someone challenge their will at a later effect. So when I know that someone's writing someone out of the will for whatever reason, personal reasons, whatever, I suggest they get a medical capacity assessment done by their doctor just to confirm. I just send them a very simple letter that says, can you confirm my client has capacity to make a will? Here's the test in order to make a will. Can you confirm that there's no medical underlying concerns? And that way I have 2 pieces of evidence for my client if the will was ever to be challenged later on. Number 1, a letter from the doctor confirming that there is capacity. And of course, 2, myself, who confirms by my own evidence and my own assessment of the individual for signing the will. Now, it's not always that I do a letter to the doctor or anything in every case. That's not the case. I only do it if I consider there's some red flags to watch for. If, for example, I know that there's someone going to potentially be challenged the estate, or if I see that there's some kind of concerns, if I'm suspecting something unusual, then I'll say, well, we should get your capacity assessed. So often, for example, I ensure that I always meet with my clients alone with no one else in the room. And sometimes someone might come in and say, well, I want you to meet my mother, and I do all the talking for my mother, and they don't let the mother talk. Well, that's a red flag for me to say, you know what, there's something going on here, because my job as the lawyer is to make sure that, number one, the instructions are coming from my client, i.e. the testator, and not from somebody who might be trying to influence them to make their will in a certain way. In terms of undue influence, now undue influence is kind of a separate issue, and it is difficult to prove because it's often happening behind closed doors. You don't know that something is happening to the individual or the testator. So undue influence actually requires the actual exercise of coercion such that the free will of the will maker is overborne and the will maker creates a will or gift that they did not intend. Of course, the onus of proof with respect to undue influence lies on the party attacking the will. So again, this is sometimes difficult to prove because it's happening behind the closed door. So if you see that joke there on your screen, sign the will or else, right? Like you can't see the or else because you're not seeing that happening. So again, as a lawyer, when I'm meeting with clients and signing their estate plans, I watch for those red flags if I see something going on. Who's calling me to make the appointment? I make notes of that circumstance, of who's called, who brings the person into the appointment. You know, are they insisting to be in on the appointment? Now, luckily, I haven't had too many where it's been insisted that they stay in the room, but I have unfortunately had situations where they have said, you know, no, I have to stay in the room while they take instructions. And I'm very much aware and have red flags and ensure I book separate appointments to meet with the individuals so that I can ensure that there's no undue influence. Now, I've had a case dealing with undue influence before. I'll just kind of give you an example where it might be difficult to prove. My client was the niece of her aunt, who was an 85-year-old woman. She had no kids. She was not married, but she did have a really good relationship with her sister and her niece. But unfortunately, the sister and the niece lived in another province. And so she didn't see her aunt very often, but she would call and check on her and kind of call in to see how she was doing. And sometimes it started to get strange because she would call her aunt and the aunt would basically tell her not to come, don't come visit me. She was making comments about people out to get her and that that something was going on. She just didn't feel right. So she eventually came to see her aunt and of course noticed that there was issues with respect to her capacity. So she brought her aunt to be assessed and of course she found out that she didn't have capacity. And so we had to activate the power of attorney and the personal directive to help make financial and medical decisions for the individual. Now in the power of attorney and personal directive, the niece in fact was appointed to make those decisions for her. And unfortunately, because of her medical state, she had to be moved to a long-term care facility. And so the niece, as the attorney, decided, well, I'm going to sell the property because she no longer needed it. So she went to sell the property or list it for sale. So we had to confirm if in the will, what was in the will to make sure that we could sell the property, listed it for sale. And of course, the individual we ended up finding out under the will that, quote, the dog walker, the guy who was helping this old 85-year-old lady to walk her dog, had her sign a will that left everything to him. When she went to list the property for sale, he got really angry about the fact that this house was his and he couldn't believe what was going on. So unfortunately, there's obviously some concerns about some potential undue influence that was going on and what her capacity was like, because unfortunately, the niece wasn't with her aunt every day and when things were happening and changing. So that's a kind of an issue for the court to decide whether or not there's undue influence in that case. But again, it's sometimes difficult to prove. So how do we avoid these kind of things? So how do we protect against issues with respect to capacity and undue influence? Kind of as we discussed, the good thing is having independent legal advice where we as the lawyers can act as your witnesses in the event that it's challenged. So Our notes become relevant, our recollection becomes relevant. If you're doing it on your own, you don't have that independent witness that can act for you. And of course, in some circumstance, we may request the medical opinion, which then would become evidence if a will is challenged as well. And of course, we can help document the actual intention. So again, if someone is writing someone out of a will for a certain reason, we can write those issues down or document that intention so that we have a record being like, oh, well, they, for example, might not have a relationship with that individual, or maybe one of their children is really well off and the other one's not. So they just really want to leave it all to the other child. So we make notes of that. It might not show up in the will itself, but it does show up in our files when we're meeting with clients so that we can help protect against challenges that might happen with respect to capacity or undue influence with respect to a will. So I know we're kind of moving along here and we'll get to some questions later. So just a reminder as we're going through, if there's anything that I've talked about and you have questions about it, go to your screen and go to the question period and you can put your question in there. And then at the end, I'll come back to your question and answer it at any time. So feel free to look on your screen for the little question and answer button, and then I will answer your questions at the end of the presentation. Okay, so the next issue that we're going to discuss is under family maintenance and support. So family maintenance and support claims is a claim under Alberta law, under our Wills and Succession Act, with respect to someone called a family member. Now, normally, again, under typical terms, a testator has complete freedom to decide what they want to do with their estate. So normally you can give your property to whoever you want, with the exception, of course, of family members. So not saying that you can't write someone out of your will, but you have to consider them and consider their circumstances when you're preparing a will. And again, this is something as a lawyer that I watch for or provide my clients with advice for when I'm drafting their estate plan so that we can avoid challenges that might happen later on down the road after someone has passed. So who is a family member? So that's someone always asks me, well, what is a family member? Who does that mean? So family members under Alberta law, and just so it's clear that if you have property in other jurisdictions, so for example, you have land in other jurisdictions, the law is quite different in other jurisdictions compared to Alberta, okay? So a family member under our act here in Alberta includes specific people, including the spouse, an adult interdependent partner, what I refer to as a common law partner, a minor child, an adult who is unable by reason of mental or physical disability to earn a livelihood, or a child between the ages of 18 and 22 and enrolled as a full-time student, or a financially dependent minor grandchild or great-grandchild. So those are the people under Alberta law that can bring an application for maintenance and support. Now, again, it is quite different in other provinces, so I have to be wary of that because people always wonder, well, what about my property that I have in BC, for example? BC law is a lot different than Alberta law. And I'm not going to go into detail about that, but again, an adult child in BC can challenge an estate versus in Alberta, an adult child can only challenge a estate if they, for example, have a mental or physical disability. So that's kind of the reasons you have to be wary not only of where your will is or where you live, but also where your property might be, because the different laws from the different jurisdictions can apply. So again, looking at the family members, it's not that they automatically will change a will or that you have to include them in it. Family members who do not receive the entire estate that are defined under the act, like we just went through, they have to make an application for a greater share of the estate if for some reason they feel that what they received is insufficient for their maintenance and support. So again, it's a right to make an application, but it doesn't necessarily mean it will be successful. So it's not an automatic right at all. So they would get served with an application for probate and get information, but then they would have to actually apply to the court. So, an application for family maintenance and support has to be done within 6 months of the issuance of the grant of probate. So the individual would get served as a family member under the application for a grant or a grant of administration to decide whether or not they have a claim under the family maintenance and support provisions. The test under family maintenance and support claim is, did the deceased adequately provide for proper maintenance and support of the family member in life and on death? So people always ask me, well, what does that mean? Like, why can't I just do what I want to do? So we have to kind of look to what it means for adequate maintenance and support. So adequate maintenance and support might be different for one person compared to the next. And it might depend on the size of the estate and how many claimants are against the estate, because someone might, for example, have a spouse plus minor children. So there might be more than one claimant as against the estate. So we look at kind of a two-part test generally. The will maker has two obligations. One is the legal obligations, and number two is moral obligations to the claimant. So the variation, of course, is determined based on what society would consider appropriate in the circumstances. So what do you think in the circumstances should the person be entitled to if they're not left the whole of the estate? So I'm not going to go through each of them in detail, but I'll just kind of give you a general overview with respect to what legal obligations are, because people ask me, well, what does legal obligation mean? So when I'm meeting with a client and signing documents and they say to me, you know, example, it's a blended family and they have a new spouse and minor children from another relationship. Well, I have to talk to them about what are their legal obligations to make sure that we're balancing the needs of course, a new spouse and the minor children under the other relationship. So we have to look at it as a holistic approach. So legal obligations are generally what would be imposed by law on the will maker during his or her lifetime. So looking at the spouse, so again, the individuals are married, what would they have been entitled to on divorce? So if they had divorced the day before the testator had died, what would the spouse have gotten? That's kind of your starting point. So it's not that's what you're entitled to. That's your starting point under a legal obligation. And then for an adult interdependent partner, and maybe I'll just back up and kind of describe what that is. So an adult interdependent partner in Alberta is what often people call as common law partners. I refer to them as APEs because that's how I define them as. So who is an APE? An APE is an individual who's been in a relationship, who's been residing together for a relationship of interdependence for a period of at least 3 years. Or of course, there's a child of the relationship of some permanence, or if there's an agreement to be adult interdependent partners. So depending on the circumstances, we have to kind of look at, are they adult interdependent partners or not? And do they have legal obligations that are founded under that? So under legal obligations for a family maintenance and support claim, what an APE is entitled to can be found two different ways. The first of principles is called unjust enrichment principles. So based on what did you kind of contribute to the relationship and what would you be entitled to if your relationship had broke down again the day before the testator had died. And then recently under the new act called the Family Property Act, what would the adult independent partnership be entitled to under that act? So this is an act, I don't have time to go in details for purposes of today, but it really depends on when the relationship broke down. This new act, the Family Property Act, came into effect on January 1st of 2020. And basically it gives adult independent partners property rights for equal division of property on the breakdown of the relationship. So previously, only married spouses were entitled to an equal division of matrimonial property. Now under the new Family Property Act, adult independent partners are entitled to equal division of property during the relationship as well. But it kind of has to look at when the relationship broke down and what applies. So i.e. if it's prior to January 1st, 2020 that they had broke down, arguably then you would go under the unjust enrichment principles, or after January 1st, 2020. So we really have to look at that and sometimes you don't know exactly when a relationship started and when a relationship ended. So we have to look at that. And then of course, another family member, a common family member that we see are minor children. So again, for a minor child, what would the legal obligations be dealing with child support for that child? So that's kind of your starting point for legal obligations. The other obligation that we talked about was moral obligations. So under moral obligations, we kind of look at that in society's reasonable expectations of what a judicious person would do in the circumstance by reference to contemporary community standards. And there's various factors to consider for moral obligations. And again, for the purposes of today's presentation, we don't have time to go through everything, but it does talk about, for example, the size of the estate. Are there other claimants? What was the person, standard of living before the relationship, right? Or before the deceased died. And these factors are defined in legislation as well as in the case law. But again, we have to look at the facts on each individual case. It's kind of not set in stone, but you have to consider the age of the person, the health of the person, like what's the likelihood of their needs increasing? What happens if they have a disability, or the contributions that they made to the estate? So again, there's lots of factors to consider. So every case has to be determined on its own facts, because we consider both legal obligations and moral obligations. So our starting point is legal, but sometimes these moral obligations may change to what might be adequate maintenance and support for the family member under the legislation. And of course, people always ask me, well, what about prenups? What happens when I have a prenup? Does that not mean that they wouldn't be entitled to my estate? Unfortunately, in Alberta, you actually can't contract out of the family maintenance and support provisions under the Wills and Succession Act. So even though you might have a prenup, it doesn't necessarily mean that someone can't make a claim against your estate. Now, it is a factor that the courts consider, i.e. that you signed a contract that basically said you weren't going to make a claim against the estate. But sometimes circumstances change where you might be entitled to be able to claim for additional maintenance and support if you felt that what the testator had left you was insufficient for your needs. So, and again, there's lots of case law for all different types of family members, and we can kind of go through them. And if you have any specific questions after, you can let me know in that chat box. So how do we avoid or minimize these types of claims? So this is something that when I'm meeting with a client in preparing their estate plan, to make sure that we're putting a proper estate plan in place to be able to reduce the potential claim that might happen as against the testator's estate. So ways to avoid them, of course, we can talk about the use of joint tenancy. So if it's joint tenancy with a spouse, for example, the property might go by survivorship. So the only thing that someone can claim for a family maintenance and support claim is actual property in the estate. So if it falls outside of the estate, that's not something that would be caught by this. Of course, there might be gifts before death, or maybe you have beneficiary and insurance designations. So example, you have RSPs or tax-free savings account or life insurance. Those again often pass outside of the estate. So that's something that I talk with my clients and make sure we're properly advising on. It's important to make sure, again, you have proper advice in doing these kinds of claims, especially again in blended families. This is where I often see a lot of family maintenance and support claim is in the blended family situation. So if you know someone who has a blended family, it's important to get that legal advice, because I often see competing claims in that regard. I had recently dealt with a situation where a testator decided, excuse me, to leave his RSPs to his children and then left the residue of his estate to his spouse. And he did it on his own without any legal advice or anything like that. And I believe he didn't understand the legal ramifications of that, because the RSPs, of course, he designated to his children from the first relationship and then left the rest of the estate to the spouse. But because the RSPs went to the children outside of the estate, and the estate then had to pay all the tax on the RSPs. So in the end, the spouse who was trying to plan to leave everything in the estate was left with all of the debts of the estate and basically was left with nothing, because she had to pay the tax on the RSPs, the other debts of the estate. And in the end, by the time she got paid, it was only about $2,000 from the estate that she got. Clearly not what the testator had truly intended. And so we have to kind of deal with that and make sure that our clients are getting proper advice. I look at it as a holistic approach when I'm dealing with my clients. I'm working with you, your financial advisors, and making sure that we're all working together and your accountants to make sure that you have that holistic plan that includes any assets outside of your estate, any assets that are in your estate, and of course the tax consequences that are related to that, because we want to avoid any of these types of claims down the road. Because again, the cost to put a proper plan in place by involving all of the moving parts in your estate plan is much more minimal than if we have to fight over them after the fact, right? We can also use alter ego trusts or joint spousal trusts or common law partner trusts in setting up ways to avoid family maintenance and support claims, or making sure that your wishes are properly documented. Now, again, as lawyers, we act as witnesses in terms of a potential claim against the estate to make sure that we've considered it. And myself, I actually always kind of make a note in my draft will itself saying that I've considered the family maintenance and support provisions if I know, for example, that there's a potential party who might come forward as a potential claimant. So again, whether they have minor children and a current spouse or blended family, or maybe they have a child with a disability, that I've considered that in drafting the documents, and that I've made notes to my file to say, here's what's in the estate, and here's why I think it's reasonable in the circumstances that what we're doing in this estate plan is a good idea. So we have that valid and rational reasoning in writing. Again, it might not be in the will itself, but it likely would be in my file addressed to my client. And again, we can act as providing independent legal advice to the clients. So that's it for family maintenance and support claims. Again, if you have questions, you can go ahead and put them in the chat bar and I'll come back to them later. I know it's a bit different format when we're online because I can't see anyone either, but we'll kind of move on. The next issue that I wanted to talk to you about is issues with respect to joint tenancy. So people always think, well, if I put property in joint names, i.e. my spouse, if something was to happen to me, it's automatically going to go by survivorship. So is that true or false? Because people always wonder, how's that dealt with? Well, from my point of view, as an estate litigator, that's not always the case. So I want to kind of explain two concepts to you. The first concept, of course, is joint tenancy itself. So the intention of joint tenancy is if one of the owners dies, then on their death, the right of survivorship would apply, and the other joint owner would automatically become the owner at the time the other person dies. Versus tenants in common. So if you were tenants in common on, say, a real estate property, and basically it says 50-50 as tenants in common, then on the death of one of you, your 50% share would go into your estate and the other 50% would remain with the other title holder. So how does that affect estates? Well, this is a big actual area of issue for estate litigators, and it's a huge cause of estate litigation. So joint tenancy and problems that arise with joint tenancy actually can apply both to bank accounts or real property. So there's actually case law in Alberta that says if you have joint tenancy with someone other than your spouse, so say it's with an adult child or some other person other than your spouse or adult independent partner, this actually gives rise to something called a resulting trust. So in our point of view, we basically say that the property is actually still belonging to the estate of the individual person, like i.e. if it's a parent and child, and the parent dies and the child's name is on title, the law presumes that in fact it would go to the estate. So there is a resulting trust back to the estate. But unfortunately, land titles and banks don't necessarily keep that same view. So it becomes a significant source of litigation. A good example of that is with bank accounts. So often as parents get older, one of you might say, well, I'm just going to add my child's name to the title to my bank account because it makes it easier. They can just help me to do my banking. And, when I die, I know they're going to do the right thing and it's going to form part of my estate. So I recently had a situation where a mother had added her two sons as joint owners on her bank account. So filled out the paperwork at the bank that gave right of survivorship to the two sons that basically said, if something should happen to me, Then, of course, when I die, then it goes to my two sons into my joint bank account. So when she had capacity, she filled out that paperwork. But really, the intention for her when she added her sons' names was just so that they could help her, like help her pay her bills, or if she can't get down to the bank, that they can be there for her. And when she lost capacity, so mom basically was unable to continue on because she was diagnosed with Alzheimer's. So the sons then decided, well, we have to move mom to long-term care. So they ended up putting mom into long-term care and sold her house because she no longer needed it. So they sold the house and then they put the proceeds from the sale of the house into the bank account. And of course, it's a joint account. Whenever you have joint account, you know that anyone can access that account at any time. So the two sons put the money into the joint bank account. The one son, within a few weeks, took out all the money from the account from the sale of the house, basically drained the account so there was nothing left. He unfortunately had an addiction and gambling problem, which the other brother wasn't aware of, took the money and spent it all. Now, from the bank's point of view, truly it said it was a joint account, so he had perfect access to be able to access that money. But that truly wasn't the mom's intentions. The mom's intention was adding the son's name on title so he can help her. Now, again, she had lost capacity, so she didn't know that her son had taken the money. So the other brother had to bring a court application to have the brother removed as the attorney and to return the money to the bank account. But again, it was too late. So it became a real problem because the mother had added the name to the joint account. Ways to kind of avoid this is having a power of attorney where you're appointing someone to look after your finances. If, for example, you become incapacitated, and then they can go in and make sure that your bank accounts are looked after, which doesn't give them the right to be able to access that money, right? So it's a big difference by just, someone saying, well, I'm just going to add my child's name to title because it's easier. It actually causes a lot of problems when you do that. People often don't consider all the factors in dealing with joint tenancy. So for example, what are the tax consequences in treating that property for income tax purposes? So again, it can happen with real property as well, and not just bank accounts. You can actually expose your assets, so whatever joint property that you have, whether it's your bank account or maybe it's your real property, to actually creditors of that joint tenant, including other family law claims. So again, using that example we talked about earlier, where the mother added her two sons. So what happens if one of those sons was going through a divorce? Well, arguably that's a joint account. So arguably you could say, well, that's a matrimonial property asset. So we could try to make a claim against that. Or maybe the son who has credit issues, maybe he's got somebody coming after him for a debt that's owed. Well, arguably he can try to access that money, or at least part of it, in order to make a claim. And it might not be a child either. I mean, it can happen in any circumstance. I had another matter where we were dealing with a joint tenancy issue where the testator had basically said, in his will, said, I leave my property to my three friends, and I appoint my one friend as the executor of my estate. So he appointed friend number one to be the executor of estate, and basically said, I divide my estate equally between my other three friends. And he added the executor's name to the title to his home because he wanted to avoid probate. Now, probate fees in Alberta are very minimal in comparison to other jurisdictions. So from our point of view, if that's something you're planning to do, is just adding name to title because you want to avoid probate, from a legal point of view, we recommend do not do that, because you have all these other problems and consequences that can happen just to avoid probate fees. To give you a good example, probate fees in Alberta are a maximum, I believe, of $575 for the probate fees, versus, of course, you can have someone making a claim against your estate and cost thousands and thousands of dollars in order to try to get the property back. Now, in other jurisdictions, you might set up your estate plan differently, like using BC as an example, because their estate fees are quite a bit higher than they would be in Alberta, because it's a percentage of the estate. I believe it's about 1.4% of the value of the estate. So again, different planning in different jurisdictions. So that's the beauty of making sure that you have independent legal advice when you're making your plan. But going back to that example, the individual who added his friend number one to the title to his home because he wanted to avoid those probate fees, which again aren't very much in Alberta. But the friend basically said, oh, my name's Untitled by joint tenancy, so the property is mine and I get to keep the land. And of course, the other friends are like, no, like he's always told us that the property gets shared between all of us. It's not yours. The executor had listed the property for sale and basically was saying, nope, it's mine, and too bad for you. We had to bring an urgent court application and file a claim, putting a lis pendens against the property to prevent the sale, to be able to basically say, no, this property was in fact truly belongs to the estate under those resulting trust rules, rather than truly a joint survivorship issue. So again, there's lots of costs involved and trying to prevent that sale from going through. Now, luckily, once we filed the claim, we were able to come to a nice settlement to make sure that that didn't happen. And we had strong evidence that supported the fact that it truly was not the intention of the testator, that it was supposed to go to the friend for his personal use. It was in fact documented by notes and other witnesses that said, in fact, it was supposed to go into the estate. So we were able to kind of deal with it. But you have to be really, really careful of that when you're dealing with joint tenancy issues. You also have the loss of unilateral control of the property. And this is something people often forget too. Again, they're thinking, well, it's so much easier if I just put that person's name on title, right? So I'm going to add my child's name to title because it's just easier if something should happen to me. So, but you do lose control of that property if you decide to change your mind. Again, I have a situation where a client who's an elderly gentleman, he's a farmer, been farming his whole life, added his son's name to title to the farm because of course he thought that was the easiest way to be able to transfer it. But the farming relationship actually broke down and the son and the dad can no longer be farming together. And of course the son won't sign the property back to the father. So now we have this ongoing litigation matter that basically talks about, well, whose land is it? What was the true intentions of the time when the transfer was done? So, and what are you entitled to in order to get the property back? I.e., if it's truly joint tenancy by survivorship, what are you entitled to? Can you get it all back? Or are you only entitled to say 50%, like by severing that joint tenancy? So you really have to be careful because it's a lot harder to change your mind once you've gifted that ownership over. So we have to make sure, again, as lawyers, that we're properly preparing for that. So ways we can avoid that, to avoid that resulting trust, of course, is we can give property as gifts outright during lifetime. Of course, we can document the intention, so making sure that it's properly documented if it's truly meant to be by survivorship or if it's truly meant to be a resulting trust. And when you add your child's name to title, if it truly is to be by right of survivorship, we just make sure to execute documents to make sure that intention is properly documented. So example, we do execute a deed of gift to ensure that you will have that gift done. And of course, it doesn't necessarily mean that if you put it in joint tenancy and you want the right of survivorship to apply, that your wishes won't be that, because the person can, of course, prove the fact that it was the gift, which is what happened in that example that I told you before. We were able to establish that the testator's true intention, so it was that it wasn't a gift, but we can do it the other way if it truly wasn't meant to be a gift. So again, we can act to give independent legal advice to clients in dealing with joint tenancy property. So then looking at that holistic approach, not just what your will says, but what assets do you have? How are they held? When you're meeting with a lawyer to do your estate plan, often you'll be sent a questionnaire to fill out to kind of talk about, well, what kind of assets do you have? It gives us an idea to know in terms of, do you have named beneficiaries in your estate, or do you have property that's joint tenants or not? Because we may give you different advice depending on the assets that you hold. So I know as clients, you get these questionnaires and you're like, you're a little overwhelmed by how much information is asked for in it. But the reason why we ask for all that information is just to make sure that we're giving you proper advice and making sure that we're covering all aspects to avoid these legal claims down the road. Now, it is daunting at first, but it's best to spend that little bit of time in advance to make sure that you have anything in place. Okay. And then the next issue I wanted to talk to you about, and I know I'm running a little early, we still have about 10 minutes. So again, don't forget to put your questions in the question box. So one thing I wanted to talk to you about, and one of the reasons we're here today, is dealing with charities. Now, Edmonton Community Foundation and there's other charities that it's very important in dealing with your estate plan to make sure that you have your charity properly named. So the charity has to be named in accordance with how it's officially done. A lot of people misname them, or the charity name is ambiguous. So just imagine how many, for example, St. Paul churches there are out there, and you say, well, I want to leave my estate to the St. Paul Church. Well, there may be several St. Paul Church. What church do you mean? Do you mean the one in Edmonton? Do you mean the one in your local town? Do you mean the one in perhaps your town that you grew up in that might not even be in this province? So it's important to make sure when you're doing your estate plan to make sure that you're naming them properly, because that's a common thing that I see often, especially in a holograph will or someone who's done up the will themselves, where they've named a charity, but they weren't specific enough. I've often had to bring court applications to have a charity named to make sure it's the proper thing. So what I look for in evidence to try to make sure to figure out what the testator went, I go through their mail. Well, what charity were they donating? I go through their tax returns. What charities were they donating? But again, I'd still have to bring a court application to validate the charity that they truly intended. Versus if you just kind of put the plan in place to begin with, we could avoid all of those costs, because often the reasons you're naming a charity is, of course, to take advantage of some tax rules. We also have to make sure when you're naming charities in your estate plan that the gift may contain a problem condition. So say, for example, the gift is for certain work, but that charity doesn't actually do that work. So maybe it's too restrictive or it's too ambiguous. You don't know what it is and what that charity has to do. So you want to make sure that it's properly named. And sometimes we coordinate directly with the charities to make sure, okay, can we set this up? And again, talking with the Edmonton Community Foundation, when I know I have clients who want to do or be involved with the Edmonton Community Foundation, and they want to leave it to a specific organization within that, we have the talk and we have those conversations so that these kind of problems and conditions don't happen on someone's death. Another problem that happens for charity is when the executor or the personal representative fails to claim the charitable donation tax credit for those gifts. So again, we want to be able to maximize the value of the estate and minimize the tax. So executors have to be aware of that when they're dealing with charities. And of course, the gift to the charity has to be received within the 60 months after the death of the testator. So again, if you don't, then it could not result in the tax savings, which was usually intended for the testator at the time. You can also have problems with tax savings not being maximized. So for example, maybe in your estate plan, you have publicly traded securities. Well, of course, you can transfer those directly to a charity in kind instead of cash, would result in, of course, significant tax savings, which often people might not be aware of if they're not involving all the proper advisors involved. So you want to make sure that you talk with your advisors, talk with the charities, make sure that it's properly named when you're doing your estate plan. Otherwise, you get to come visit me as an estate litigator to try to figure out what it is that you meant after the fact. So best to do it in advance rather than kind of later on. And that's what a lot of the presentations later this week is going to talk about and give you information about of how to do a proper estate plan. So what can you do going forward? So the next steps, of course, in your estate plan, of course, is to organize your affairs. make sure to communicate and take action. That's the key thing. Like, you have the power to do your own estate plan. You have the power to put your will in place and your power of attorney and personal directive so that you can avoid these kind of legal challenges later on down the road. If you have a will that's properly prepared, it's done with proper legal advice, not necessarily do-it-yourself will kits, you can avoid all these problems. So making sure you're doing that inventory, considering all your assets as a whole, not just separately, like not dealing with your RSPs in one area and then dealing with life insurance in another, and then dealing with your estate, because all of them work together and can have tax consequences. So first step, organize your affairs, getting all your financial information together, talking about that questionnaire and contacting your professionals. And then discussing those. What is it that you want to do? Like having a discussion with your executors, your attorneys, your beneficiaries. What is it that you need to do to take those next steps? And of course, you have to act on those steps. So not just thinking about it, like, yeah, I'm going to put my estate plan in place, because a lot of people decide that they want to do their wills, but a lot of people don't. Like, I find a lot of clients procrastinate. They say, well, I'm going to get to it later. I'm going to get to it later. And always people think it's going to come later, but it's not. And I'll give you a good example of that in my own situation. I have two for you. My cousin, who unfortunately had an accident where she choked on a piece of lettuce, never had any of her documents in place. And if she would have, I know that things would have been different. She remained in the hospital in a coma for over 2 years while my aunt and uncle fought over what was going to happen to her, because she didn't have her documents in place. She didn't have her healthcare directive in place. And so it just became a litigation battle of what was going to happen. Another example, which is very close to my heart right now, is my own dad, in terms of making sure your documents are updated. Now, you have to not only do your documents, but keep them updated. So if you have documents dating back for several years, doesn't necessarily mean that you have to make changes, but you have to review them to make sure that they're still good. So my dad had an old will, and we kept meaning to update it, and we kept saying, yeah, we're going to get to it. We're going to get to it. But unfortunately, it just never happened. And he had recently passed away, and we never got it updated because we kept thinking, we'll get to it eventually. We'll do it. You already have one. We're just going to get to it. But significant consequences in the fact that I know that it doesn't represent his intentions, because my brother has stepchildren and they're not included in the will. Because my brother didn't have stepchildren back in 1995. But if he would have put it in place and we would have made that change, we wouldn't have to deal with that now. So key plan of advice is take your steps, organize, communicate, and act. If there is specific questions, like if you have specific questions relating to a particular matter for you, what I suggest is my contact information is on the screen right now, so you can kind of see that. So you can email me at my email address, or you can give me a call with respect to your specific question if I was unable to answer it today, and I can see if I can help you.
So thank you to everyone for participating. Jacklyn, thank you so much for your presentation. You've really done a marvelous job today. So thank you to everyone, and have a great day. Take care. Bye-bye.